So the introduction of the Divorce, Dissolution and Separation Act in 2020 led to the end of the blame game, essentially, in that it introduced no-fault divorce, and it is now no longer necessary to identify the detailed reasons as to why the relationship has broken down, and it's sufficient to say on the face of your application for a divorce that the relationship has irretrievably broken down, and that's the only detail that is required. It is also now not possible to defend an application for divorce like it was under the old law, save for in some rare circumstances. The implication of this for children is that it reduces the level of conflict at the outset. Under the old law, you were invited to give the reasons as to why the relationship had broken down, and there were 5 facts that you could rely on that, the most common of which was unreasonable behaviour. And doing this pits the parties against each other from the outset, whereas now we've removed the need to do that, and it allows for the focus of the parties to be not on the cause of the breakdown or even each other, but what they want their financial arrangements to ultimately look like, and the child arrangements. Just by way of example, some of the old case law about unreasonable behaviour went into quite eye-opening detail about the causes of relationship breakdown. For example, in O'Neill versus O'Neill, the husband was a DIY fanatic who took 8 months to replace the toilet, and that was found to be unreasonable. In Lines v. Lines, the husband required the wife to tickle his feet for hours every evening, and this was found to be unreasonable. We're no longer holding a microscope over the intricate details of people's personal lives, their relationships, or indeed the reasons for the relationship breakdown. And so from the outset, it allows the parties to focus and to detach the very difficult feelings and their feelings of wanting to be heard with the divorce process itself. And that's not only better for the children, but also it ensures that the parties themselves can reflect on the other services which might be available to them to deal with the reasons for the breakdown of the marriage and the difficult emotions that they're feeling. They might be better suited in a therapy session or over a cup of tea with their friends and family. So I think it's important, and I think it's an important change to the law, because it means that we can focus our attention from the very beginning at what the important issues are, and how best to address what those issues are. Secondly, studies have shown that parental conflict causes harm to children. In fact, the government themselves have published a document called Reducing Parental Conflict Programme, which shows that children who are exposed to parental conflict are more at risk with having problems at school, with their physical health, with mental health and substance abuse. And this can have long-lasting impacts on the children. It's incredibly difficult to navigate a divorce without any conflict, and to always have the best interests of the children in mind. But I think it's important that the legal process itself doesn't encourage or invite people to have entrenched positions and heightened conflict. As far as possible, it's important to use language which neutralises conflict. Although divorce is inevitably a traumatic experience in people's lives, and children can feel emotions both first and second hand when they're seeing their parents go through a divorce. So really thinking about how we can reduce parental conflict itself and also the impact that it has on children is an ongoing consideration for family lawyers and those who are getting divorced. Lastly, I think this change of law, which reduces the level of conflict at the outset for people getting a divorce, also better serves the ultimate goal of having and maintaining a co-parenting relationship, because the divorce itself ideally is only a very short period of time over the course of an 18-year period until the child is an adult. And it's important as far as possible to have the foresight to think about how that relationship can be maintained and how parents getting a divorce can be civil to each other and ultimately continue to be parents and hold the best interests of the child at the forefront of their own thinking.